Good morning, everyone. I'm glad to see participants online and offline on the second day of conference, Gender in the Material Labor, that was held, that organized by Center for Gender Studies, European Humanitarian University within the project Women in Tech in Belarus, with financial support European Union. And our fourth panel, Gender Equality and Anti-Discrimination Legal Practices. And I'm really glad to introduce Dr. INGRIDA DANİELėnienė, a legal academic and who will address us to the topic of Locus of a Woman in the Lithuanian constitutions. Dr. INGRIDA DANİELėnienė holds the position of head of academic social science department and is associated professor at the European Humanitarian University. She has an impressive career experience, more than 20 years. And she held, for me personally, it's very important that you have both practical and academic experience, and you also have experience in Supreme Administrative Court of Lithuania, Constitutional Court of the Republic of Lithuania, and others. So, and to my mind, the idea of gender gap and gender issues in according of legal system is really crucial in context of our topic, gender in the material labor. So we are very welcome.
Thank you, Antonina. Thank you to all. I see my task today is to briefly share some insights with you on the constitutional gender order within the Lithuanian constitution. The Lithuanian constitutional system of constitutional justice was created for the first time only 30 years ago, with the adoption of the constitution in 1992 and the establishment of the Constitutional Court in 1993. Lithuania opted for a centralized European or Kelsenian model of constitutional justice, as is very typical to the states of the continental legal tradition. The court commenced its activities as soon as first of its 9 judges were appointed, once again 30 years ago. And to this day, close to 500 acts on merit have been adopted by the Constitutional Court, on average about 20 per year, resulting in a relatively thorough jurisprudential constitution. What we lawyers refer to as the living constitution that is developed by the court through the jurisprudence of the court, and which indicates the achieved maturity of the constitutional control. During these 30 years, gender issues have also seen a generally coherent constitutionalization through jurisprudence. However, this process has been an equally slow and cautious one, mostly due to the relative scarcity of constitutional cases related to the so-called sensitive human rights, such as also gender rights. What does the concept of constitutionalization mean to us lawyers? It means the protection or the establishment of a certain issue within the Constitution. And how is this possible? This is possible in 3 ways. When certain rights, certain principles are originally enacted or written into the text of the Constitution itself. Second, if certain amendments are adopted that amend a constitution in a way as to extend it or supplement it with also such rights that were not present there from the very beginning. And the third way, which is most common, is when certain issues or certain rights are risen to the constitutional level through constitutional cases. When I speak that the constitutionalization process of gender rights and sensitive human rights is very slow in Lithuania, I talk about all of these 3 parallel methods. And the reasons for this slow process is manifold. Limited access to constitutional justice. First of all, the wording of the Constitution itself that was originally present in 1992, the political environment that is characterized to this day in Lithuania by patriarchal and populist attitudes, as well as a strengthened influence of the Roman Catholic Church, which just does not hold any special position from the constitutional law perspective, or would not say, does not hold the position of a state religion or similar from the constitutional perspective, but is very present in law and in society. So until September 2019, the Lithuanian model of constitutional justice, along with respective models of Bulgaria, Italy, and Moldova, remained among the 4 models within the Council of Europe member states that had a constitutional court, but did not ensure direct individual access to constitutional justice. What does it mean? Individuals could not refer any questions or cases to the Constitutional Court, and this right was limited to political actors and ordinary courts. Ordinary courts were to act as a mediator, to bring cases and questions that raise doubt with regard to constitutionality, and to do so on behalf of individuals who come to ordinary courts with such questions. But we see that there were problems in this approach from many aspects. One of this is, once again, the lack of human rights issues in general before the Constitutional Court, meaning that such questions simply did not reach the court. And also from such examples, such as judgments of the European Court of Human Rights, where the European Court of Human Rights has a number of times concluded that in such cases, for example, that regard gender or the rights of sexual minorities, the Convention on Human Rights was breached inter alia by the ordinary court, not even referring any case to the Constitutional Court, even if it had to. For example, there was a case called Beizaras and Levickas versus Lithuania, which resulted in Lithuania's violations before the European Court of Human Rights. Lithuania was found to have discriminated against the applicants, 2 Lithuanian nationals and openly gay men in a same-sex relationship, on the grounds of sexual orientation on account of public authorities' refusal to launch a pretrial investigation into hateful comments left on one of the applicants' Facebook page. The mentioned applicant had posted a picture of a same-sex kiss between him and his partner. The picture went viral online, receiving thousands of likes and comments aimed at inciting hatred and violence against LGBT people in general and directly threatening the applicants personally. The applicants lodged a number of requests with the Lithuanian law enforcement authorities regarding specific comments that they deemed to have been inciting not only discrimination, but also direct threats of violence against the applicants. And the national authorities in Lithuania all decided not to initiate investigation. Such decisions were twice upheld by the national courts that concluded that in making such comments, the authors had not been inciting others to discriminate against or hate homosexuals, as is prohibited under criminal code. And the applicants were found to have engaged in eccentric public behavior that did not contribute to the cohesion of those within the society who had different views or to the promotion of tolerance. And also the courts took into the account that the majority of Lithuanian society very much appreciates traditional family values. Once again, such arguments, even coming from courts, are not and were not considered as sustainable legal arguments by the European Court of Human Rights. So this example shows that the courts, the law in Lithuania have always had a very limited approach towards the protection of human rights, especially sensitive rights, and inter alia rights related to women. In fact, when it comes to the constitutionalization of human rights through constitutional legislation, we also see many problems. For example, as concerns unceased possibilities of initiating normative control of laws and other acts of ordinary law, and thus possibility of constitutionalizing relevant aspects of gender equality, the following could be mentioned. Lithuania remains among the 6 EU member states that does not ensure legal recognition of civil partnership. Legal provisions de facto establishing the right to civil partnership were included in the so-called new civil code in 2000, 23 years ago. And it defined a registered partnership between a man and a woman as something, as partnership between those living together for at least 1 year without registering a marriage. However, the entry into force of this relevant provision was connected to the adoption of a special law on the establishment of registers for partnerships. And such a law to this day has not been adopted. There are processes before the parliament currently this month, but these processes are slow and they do not bring any promises of success. Once again, this is not an exclusive example. In Lithuania, the right to assisted reproduction is available exclusively to married couples, while the rights to women's reproductive autonomy are neither constitutional nor statutory ones. What does it mean? The right to abortion, among others, is regulated not by the law, but by the order of a Minister of Health, which, due to its very low standing in the hierarchy of legal acts, is not even an object of review by the Constitutional Court. And with regard to traditionally even more debated rights, such as the right to gender reassignment, Lithuania stands firm for more than 15.5 years in refusing to execute a judgment of the European Court of Human Rights of September 2007, L versus Lithuania, that inter alia has obliged it to pass the required legislation on gender reassignment of transsexuals within 3 months of the present judgment becoming final, meaning that the European Court of Human Rights obliged Lithuania in 2007 to pass a law that has not been passed to this day. So what does it mean? Constitutionalization, or the protection of gender rights and human rights through the practice of the Constitutional Court, then remains the only alternative of the protection of the establishment of such rights at the highest level, not through political means, but through legal means. With regard to women, the Lithuanian constitution does not establish the concept of a woman individually, or does not establish any rights that would refer to a woman specifically and the position of a woman within the Lithuanian legal or constitutional order. As regards gender order in Lithuania, the most prominent developments relate only to social rights, the constitutional clauses on motherhood and family protection. The jurisprudence of the Constitutional Court has developed these guarantees expressively, established in the text of the Constitution not merely as constitutional principles, but also as enforceable rights, thus also acknowledging even a higher standard of protection with regard to certain family rights than the European one. For example, the Constitution expressly establishes the constitutional guarantee of paid leave before and after childbirth for working mothers, the so-called paid maternity leave. And according from paid maternity leave, the provisions of the Constitution also entail a clause that recognizes the only time recognizes affirmative action with regard to working mothers, and according to the court, to a certain level also extends to non-working mothers. Now, in concrete examples, how does this work? Within the Lithuanian constitutional order, maternity leave guarantees are expressly developed in a manner as to substantiate the special status of a woman, mother, and her relationship with the newborn child. The purpose of the constitutional guarantee of paid maternity leave, which is a leave before and after childbirth for working mothers, this is how it is understood, is twofold. First, it relies on the need to secure the protection of the special physiological condition of a pregnant woman and a woman after childbirth, the need of health care of women for some time before and after childbirth. Second, to secure the special link between the mother and a child during the first weeks of life of the child, by creating the possibility for a working woman to withdraw for a personal time, for a reasonable time from her work professional activities. And a number of cases regarding various aspects of this constitutional guarantee of paid maternity leave have now been heard by the Constitutional Court. All of these cases were brought to it by ordinary courts, which were examining claims of women. For example, the Constitutional Court, after hearing one case, has stressed that taking into account its constitutional purpose, paid leave before and after childbirth guaranteed to working mothers is a specific constitutional institute of the protection of motherhood and childhood. The court addressed the issue of the constitutionality of the provisions in force at the time, establishing that maternity allowance amounts to 100% of the compensatory earnings of the mother's allowance. However, such compensation, the law said, may not exceed the maximum of such earnings that were defined by the government, which often which equated to about 800 euros, meaning that the law guaranteed 100% of compensation for a period of 5 months for a mother, but there was another clause that limited this 100% to a sum of 800 euros. And the Constitutional Court clearly and obviously decided and concluded that such protection of the law does not fulfill the constitutional guarantees that are awarded to a mother. And during this period, what the Constitutional Court concluded is this full compensation of the full allowances during this period of 5 months is a special guarantee of the Constitution and should not be limited or restricted by any numbers and by any laws or other acts. What the Constitutional Court also noted in a similar case is that this right and this guarantee that relates to maternity rights for the 5-month period that is divided into a period before birth and after birth also extends not only to working mothers, but also to mothers that engage in individual professional services. And also this is required by principles of non-discrimination and, once again, principles of constitutional protection of a mother. And the same principles also determine the guarantee that has to be applied to those mothers who have contributed to social insurance to the extent provided for under law, but due to objective reasons, ceased their professional activity before the day on which, under law, they would become entitled to paid leave before and after childbirth. What do I mean? There were certain clauses that did not extend the same guarantees to mothers or women under 26 years of age who were entitled to a maternity allowance without completing, due to their studies, the established qualifying period exclusively in cases where they had become insured only for a certain period of time. So once again, the Constitutional Court ruled that such and same guarantees should be available to all mothers, including young mothers who did not have the chance to meet the professional experience requirements before the birth of a child, and also to women who engage in professional sports and could not work for a longer period before childbirth than others. Once again, such guarantees are tied exclusively to motherhood and, as I have stressed before, not only any mother, but simply a working mother. What are the other constitutional guarantees? The other constitutional guarantees that refer to mothers and fathers alike, they call for a safe and sound environment while raising a child, and set the tone for certain, let's say, for a certain approach of law that would look favorably towards families and including women raising child. So according to the Lithuanian constitution, the position of a woman, let's say, is twofold. The text of the constitution establishes a classic catalog of constitutional rights and principles. Some rights and principles have been developed in a way that they protect the rights of a individual, including men and women, to quite a great extent, such as principle of non-discrimination, principle of the anti-majoritarian approach to human rights, requiring that all human rights, irrespective of their support in the society, be protected. And such principles, as developed by the court specifically, they provide for a quite high threshold of constitutional protection of human rights. However, as regards the constitutional gender order, substantive sex equality, meaning real, not just legally formal equality before the sexes, the right between the sexes, the rights of women and sexual minorities, the Constitution mostly remains silent to this day. And the Constitution to this date has seen a total of 10 constitutional amendments. None of these amendments have had direct relevance to gender order. The constitutionalization of gender issues is therefore most dependent on the consistent development of the jurisprudential constitution through the acts of the court. And therefore, while the possibility to apply to the constitutional court directly by individuals, including women, since 2019, must be seen from the academic and legal perspective as a tool that should guarantee a higher threshold of the protection of gender rights, including women's rights, practice will only show how this will work out in the future. Thank you.
Thank you so much. And probably we have several questions, and personally from me, you mentioned the abortion situation, and for me, it was very, for me, surprisingly that it's protected, first of all, by Ministry of Health Care, and how you analyze the situation that, especially in the context that today many countries again prohibited the right for abortion. What is the situation in Lithuania about it? And do this situation that the right for abortion protected by only Ministry of Health Care make this situation so fragile?
Thank you for this question. Indeed, I specifically like to mention this legal regulation of the right to abortion, or the right to reproductive rights, the right to the integrity of a woman's body. Yes, indeed, in Lithuania, we have a legal regulation that is quite, in a way, liberal to this day, and quite stable and quite foreseeable. So the order of the health minister, it sets down the conditions that are mostly tied to objective factors such as the development of the pregnancy, medical conditions, and other conditions that allow the women to choose and to adopt the decision. So from the legal perspective in Lithuania, abortion or decisions on reproductive health in the form of adoption are legally allowed, acknowledged until the let's say the term of 12 weeks, and then with certain exclusions for a longer time. However, practice, as you have correctly indicated, in other countries, different practices show that the legal regulation of reproductive rights, which are human rights, on a level lower than the legal level, than that of a law, is insufficient, and even from the legal perspective unconstitutional, because even Lithuanian constitutional law declares that all human rights, all essential individual rights should be protected and in cases restricted when needed only by the law, not something of a lower nature. We heard COVID restrictions, so this was a discussion, I think, that was evident to the general public. And in Lithuania's case, this does not satisfy this formal criteria. What does it mean? A ministerial order is something that is very easily adopted, but it can be very easily changed, recalled, repealed, meaning it's an individual act that is signed and adopted by one individual, and it can also be amended and changed individually. So under certain set of circumstances, the legal regulation of reproductive rights can be completely changed, transferred in the course of 1 hour, 1 day, because even unlike laws, we don't even have any terms or special procedures for the adoption of ministerial orders. Above ministerial orders, we have governmental orders, and we have also laws, and then we have the constitution. So once again, on any of these levels, if the state were to adopt a different approach, this can be easily done. And this means that this is a very weak level of protection, very weak foreseeability, and it can come and go as it pleases. Why is it so? Because it's a sensitive issue, and probably none of the governmental institutions want to raise this issue, not the parliament, not anyone else. And I think that, once again, constitutionalization through the development of constitutional jurisprudence is one of the ways to guarantee reproductive rights in Lithuania. It is an option. But also everything depends on the court. As we've seen from the Polish examples, the issue was constitutionalized, but, and what does it mean? It was cemented. This order was cemented on the higher legal order, but not in a way as to ensure the liberal approach and the humane approach and the approach that is recognized by European and international law. So the constitutionalization in a bad manner can also cause many big problems. Thank you.
And do you have any other question? Okay.
Thank you. I know that they are same, or sorry, I'm not so close with the structure. Yeah, I know that was the second reading of law which make possible the marriage between people with the same sex, and I know that it was like the balance quantity of who supported and who are against. What do you think? What is the perspective, and how it may affect the society? Because it's like a bit like the order, like, I don't know, not Lithuanian order, maybe, like something. Thank you.
Thank you so much. Well, once again, when we talk about constitutional law, everything is very clear. The Constitutional Court developed the constitutional concept of family in two of its rulings, in 2011 and 2019. In 2011, it said that the concept of family must extend to those beyond different sex couples that have entered the marriage. The Lithuanian constitution says that the marriage is exclusively a union of a man and a woman. So a very classical, old-fashioned approach, right? But the Constitutional Court explained that family as a concept is different than the concept of marriage. And family as a concept is much wider in scope. It relies not on the formal requirements, but on the content of relations. It did not talk about, heterosexual or homosexual relationships at the time, but it laid the foundations for the development. In 2019, there was a different case where a couple who had concluded a civil partnership abroad were not recognized this partnership by the migration office. And a case resulted in the Constitutional Court, and the Constitutional Court clearly concluded that such families that are founded based on civil partnership, and civil partnership concluded in other countries, should be recognized the status of families. So in that individual case, both partners were registered as partners, and they acquired their migration documents. But what the Constitutional Court also said, that the Parliament has to regulate this issue, not through the establishment of marriage between homosexuals and heterosexuals alike, because we still have formal constitutional preclusion, but by the establishment of the partnership institution. And in a way, the Parliament has been trying to do this in a way. What you have noted is, yes, we have now, after, I've been following this situation for a very long time, about 20 years. So after 20 years, as I mentioned, in the civil code, we have a civil partnership clause, but it does not exist in practice because the Parliament does not adopt a special law that would establish a legal register, which is a form of preclusion, what is usually done when there's no wish to implement or protect human rights. So what the Parliament is now doing, based on the initiative of some more liberal parliamentarians, they are trying to legally ensure the right to civil partnership to both heterosexual and homosexual partners in the Parliament. Yes, this bill has successfully and surprisingly to some has passed the first step, the first reading. But it is still awaiting the final vote at the Parliament, and it is still awaiting the presidential signature, meaning the president has to publish, has to announce the law, and has to accept the law. So there are two hurdles remaining. Basically, from the legal perspective, the text has been worked out, it has been preliminarily approved, but there's still a long way before it becomes a real law, because the second vote is not guaranteed, and the president has a number of times voiced also his concern that if same-sex partnerships are allowed, then the traditional family values are endangered, which is once again totally against the constitutional requirements and the constitutional law. My, let's say how I see it, I think that it will be easier to achieve justice through the legal path. And there are several cases already that are started, and intentionally probably so, with different factual circumstances, and with, in all homosexual couples asking for a civil partnership, recognition of civil partnership from abroad, and etc. If those cases reach the Constitutional Court eventually, I think there are no other answers than the only answer that the state has a positive obligation to guarantee civil partnership to all, irrespective of sex. I am not very confident whether the Seimas or the Parliament will be able to do so. before that. Thank you.
Thank you so much. And I'm glad to introduce Maria ZHARYLOUSKAYA. Is distinguished lecturer and practicing lawyer who will talk about the legal aspect of gender equality in the labor market. And Maria also, since 2020, Maria has focused her work as a legal advisor on human rights issues, specializing in human rights law, international law of states' responsibility, international criminal law, and international labor law. And as I understand, we will talk today in particular about the labor law. So we are really welcome. Just one second.
Dear colleagues, good day. It's a great pleasure to present today my insights about common general legal aspects of gender equality in the labor market.
We have on the screen on right like a phone, but there it's like a.
So thank you for technical support. It can happen. So I will focus today on the international labor standard regarding to especially gender equality during the work. And I will try to change the slide. Okay. So if we try to categorize existing international legal standard, especially related to gender equality in the labor market, we can say that there is an extensive system of gender equality international legal standards that can be divided into two broad categories. The first category is general standards applicable to the questions of gender equality subsidiary, and the second category is related or targeted legal standards which are applicable to the specific issues of gender equality with targeting legal norms, especially to those this area of relationship. And if we will speak more precisely about the structure of general equality legal standards in the labor market, we can divide three broad groups. The first is general non-discrimination standards, which are applicable for all kinds of human rights. The second category is specific non-discrimination standards, specifically related to work. And the third category is specific non-discrimination standard related to sex. And all of these categories can be applicable to equality in the labor market. If we speak about general non-discrimination standards, first document is International Declaration of Human Rights. The legal status of this document, despite the name declaration, is obligatory as the general principles of law recognized by civilized nation. This means that the states are obliged to comply with this declaration and have positive and negative obligation to guarantee effective possibility of everyone enjoy guaranteed rights by this declaration. And so here you saw that there is general restriction, general prohibition of discrimination, and general rule that all persons are equal before law and are entitled without any discrimination to equal protection of the law. So it is like a general standard. All kinds of discrimination are prohibited, including sex, and all are equal before the law and have equal protection of the law. If we speak about specific non-discrimination standard related especially to work, you saw the first document is the same. It is International Declaration of Human Rights, and there's a specific article which describes common rights related to work, and you see the wording everyone, everyone, everyone, everyone. So there is no like clear distinction of categories of person to whom we can apply these norms. There is no distinction between men and women. There is no specific intention to protect women, but here it is a general guarantee, general non-discrimination guarantee. Additionally, we have a specific document, International Covenant on Economic, Social and Cultural Rights. This covenant is also obligatory as international treaty, and here we also have prohibition of discrimination, again with indication of sex. And also we have specific norms related to labor market in this covenant, which establish several categories of rights related to work: right to the work, the right of everyone to enjoyment of just and favorable conditions of work, and the rights related to formation and functioning of trade union. So here you see that there is general right, and this general right related to work is the first under protection of our previous guarantee or prohibition of discrimination on the basis of sex, and we have this right related specifically to the work, and this legal standard almost operate also by category everyone, but there is a specific mentioning of women related to fair wages and equal remuneration. So the standard said that women are being guaranteed conditions of work no inferior to those enjoyed by men with equal pay for equal work. Despite the fact that we see that women mentioned only in one paragraph of the 3 articles, there is general umbrella of second articles which protects them on the ground of sex. Also, we have like a very big portion of international legal standards, ILO jurisprudence, International Labour Organization jurisprudence. And here we have several blocks related to gender equality. First of all, it is declaration concerning the aims and purposes of the International Labour Organization, so-called Declaration of Philadelphia. This declaration is also binding because it is the annex to the ILO Charter. So ILO Charter is international treaty. And here you also see that there is general guarantee of rights of all human beings, irrespective of sex, to freedom and dignity and equal opportunity. Additionally, we have very specific document, our Declaration on Fundamental Principles and Rights at Work. And this document, despite the fact that it is declaration, in the practice and theory of international labor law, recognized as general principles of law recognized by civilized nations, and so it is also binding for the states. And here, elimination of discrimination in respect of employment and occupation is a fundamental right for everyone. And what is also important that according to this declaration, elimination of discrimination defined not only as a fundamental right but as a fundamental principle at work. And why it is important that this declaration has a specific provision that we all know that states cannot be bound by international treaty which were not signed by them. But this declaration established the statute of elimination of discrimination as principle and establishes the norm that even if the state have not ratified the specific convention or treaty in question which prohibited the specific legal norms related to the elimination of discrimination, despite of this fact, the state is still bound by obligation to eliminate the discrimination, because it is not like right but also fundamental principles and right at work. So, for example, if the specific state does not ratify the specific convention of International Labour Organization, which includes the provision related to elimination of discrimination, the state bound by this convention due to the fact that the elimination of discrimination is the fundamental principles and right at work. Also, we have so-called Gender Equality Convention of the International Labour Organization. Therefore, those conventions: Discrimination, Employment and Occupation Convention, Equal Remuneration Convention, Workers with Family Responsibilities Convention, and the Maternity Protection Convention. What is important related to these conventions that they have two directions of regulation. First of all, of course, they they really establish the standards related to non-discrimination rules, so equal rights for men and women. But additionally, this convention based on the position that gender question are not only about equality, but also about the specific condition for women, especially here in the situation, women and partly men, in the situation when the status related to family responsibilities, related to health protection, should additional guarantees. And shortly go through those conventions. The first convention is Discrimination, Employment, Occupation Convention. There is a wide range of state parties of this convention. Again, this convention is internationally binding, and this convention prohibits discrimination only also on the basis of the sex, and also give us clarification that distinction, exclusion, or preferences should have effect of nullifying or impairing equality of opportunity or treatment in employment or occupation in order to be understandable and discrimination. So this convention try to establish legal definition of discrimination, and it is crucially important for the question of gender equality in labor market, because the problem of national laws here Also, in the absence of clear definition, what is discrimination, how to evaluate whether we have discrimination or not. And here, in international treaty, which is binding, we can find this definition. So, as I said, there are two directions of main ILO non-discrimination convention, and these directions also reflected here. So we have prohibition of discrimination, and we also have possibility to establish the specific requirements, specific guarantees, if they are related to the specificity of the specific work or the specific status of person, for example, paternity or maternity or health issues. The second convention is Equal Remuneration Convention. It also has a lot of state parties, and here you see the clear guarantee about equal remuneration for men and women, and prohibition to discriminate based on sex. We have another convention regarding to workers with family responsibilities, and what is important is that this convention is protection not only for women but also for men. But here you see that there are not a lot of state parties. And for example, Belarus is not state party of this convention, Lithuania is state party, Ukraine is state party. And you see that if we have pretty clear guarantees related to wages, related to access to labor market, regarding to family responsibilities, international minimum level guarantees, we have problems. But of course, we can operate somehow the declaration on fundamental principles at work, but it is a very big and hard legal work to operate by this declaration in the national level. Also, we have Maternity Protection Convention. It's also the same situation, that there are not a lot of member state. And here we also have the specific clause regarding to employment protection and non-discrimination protection, but it is maternity convention. There is no legal instrument to protect men and on the same legal level. So the protection is guaranteed only for women. But we see that times are changed, and so maybe we need the legal standards of paternity protection also. And there are additional two legal instruments related to, main legal instrument related to ILO jurisprudence related to equality in work. It is Employment Policy Convention, which also obliges state to actively implement state policy protected the freedom of choice of employment and fewest possible opportunity for each worker, irrespective of sex. Also, we have the ILO resolution concerning gender equality at the head of decent work. It is not binding instrument, but can be used as soft law or means of interpretation of existing international and national law, because the specific of international standard, it's a very broad character, and so we always need the specific national law which clarify the specific guarantees and the general norms of international standards, and evaluation whether the standards comply with broad international standards can be possible with help of this resolution. Why? Because this resolution adopted by International Labour Conference, which is like a main body of International Labour Organization, with almost all countries of the world are member states of International Labour Organization, and it shows the level of consent between different states regarding to issues concerning gender equality at work. Also, we have as specific non-discrimination standards again related not to work but related to sex, conventional elimination of all forms of discrimination. It is binding. It is also prohibits all forms of discrimination related to women, but also includes a specific article related to elimination of discrimination against women in the field of employment, with specific list of guarantees on the all stages of working process. Also, what is important here is that we need to also look into regional non-discrimination protection standards, especially on European Union standard. And here we see that treaties which are the basis for European Union, Treaty on the Functioning of European Union, Treaty on European Union, also include guarantees of equality between women and men, and obligation of states promote social justice and protection and equality between women and men. And additionally, the value of European Union is equality between women and men. Also, we have Charter of Fundamental Rights of European Union, which includes freedom to choose an occupation and right to engage in work, and also equality before law regarding to non-discrimination standards and regarding to equality between women and men. Again, we have the specific convention for the protection of human rights and fundamental freedoms, so-called European Convention of Human Rights, and here you see that there is a restriction of a prohibition of discrimination, and the important instrument also the European Social Charter, which prohibit discrimination on the grounds of sex related to equal opportunities and equal treatment in the matters of employment and occupation. There are several articles in this charter with detailed guarantees related to equal opportunity and equality. There is a specific directive which has direct implementation for the member states of EU on the implementation of the principle of equal opportunities and equal treatment of men and women in matters of employment and occupation. What is important that this directive, additional to the specific guarantees, includes a lot of definitions which helps courts, NGOs, activists, and especially persons which enjoy these freedoms and rights to understand, to interpret what is discrimination, direct discrimination, indirect discrimination, and so how to apply the existing broad standards and how to clearly define whether we have discrimination or not. And I mentioned a very big list of international standards, international legal standards. You saw that they are applicable to this topic. General standards, which relate to all kinds of human rights. They are targeted, related to work standards, which can be divided into two groups related to sex and related to work. And it seems that all is not bad in this sphere, but also there are several core problems. The first is national implementation, both on legislation level, both on implementation level. Due to the fact that international standards are very broad, the first line, and the second is mainly based on international treaties, and we know that state cannot be obliged to sign international treaties, so establishment of international standards, the development of international standards can be not implemented by state, and additionally existing general guarantees can be not effectively implemented on the state level. And the next problem is control mechanism. This problem has several dimensions. The first dimension is, okay, we have international standards, but effectivity of the system of international protection of human rights is under question now. And you know that it also depends on the fact of whether state part of a specific international treaty. And additional problem here is the fact that for a current stage of human rights defenders' work, or current stage of, for example, trade union work, gender equality questions are not on the first place. Okay, we have a lot of reports, we have a lot of complaints related to problems of poverty, related to breaches of freedom of association, but not really a lot of specific advocacy campaign and specific complaint, specific report related to gender issues. But without effective establishment of state control mechanism, effective establishment of independent control mechanism, for example, on basis of NGOs control, and effective international control mechanism, we cannot guarantee the implementation of these standards and their development, because if we do not know about the problems of national level, how we can develop the existing international standards. And the specific point here is paternity protection. On the basis of the experience of Scandinavian countries and on the basis of general tendencies, we see that if we speak about persons with family responsibilities, in the most of countries, women have a protection, but men as fathers, they do not have effective protection. And so the equality here is like sometimes even not on the paper, and there is no enough level of international consent for establishment of specific international legal standards for it, and we can apply only like general standards of non-discrimination here. And again, it is very hard and problematic legal work when we work with national implementation level. And so this is it for today, and thank you for your attention. And if you have a question, I will happy to answer.
Thank you so much.
Thank you so much. About the last slide, about the last punct, about protection of paternity. Is it a real discrimination cases or discrimination issue, or it's just an attempt to support, an attempt to make the fathers involved?
I think that it is a question of discrimination, because paradigm of family responsibilities changed now. Not in all countries, but in many countries. So fathers do not have a legal possibility to go to paternity leave in some countries. Even if they have this possibility, sometimes it is very limited and depend on very bureaucratic procedures. For example, in Belarus, if mother go to maternity leave, it's almost clear she gives to her employee some certificates from health organizations, that it. But if we have the question of paternity leave, it should be collected as enough complex of legal documents to prove that there is a consent of family and the mother is not under maternity leave, and it is not very easy for father to go to paternity leave. And additional variant, okay, there is a specific paternity leave after birth, but somehow we have in Belarus this guarantee, but implementation of this guarantee depends only of consent between employer and employee, and there is no guarantee of payment for father for this specific period. For example, if we need to additional inclusion of father, or he is a specific intent to be included in family responsibilities. And additional question here that if we speak about post-Soviet countries, absence of these guarantees, it's like some threshold for development of concept of family responsibilities. So we have like a paradigm that mother should sit at home and work with children, and father should go to work. And if we do not have easy and understandable legal guarantees for paternity protection, of course, it will be implemented further and further that only women will be under maternity leaves. Not because they want, but because the law is constructed only for this purpose.
We have one question.
Thank you for your presentation. And what about the real practice? So is no any gap between this legislation is accepted based on these international laws and real practice? Do the companies follow these norms and standards? Thank you.
It is a very important question, and thank you for it. That this topic is almost about gaps. Because we have very great and strong formulation in international treaties, but national implementation, as I said, first of all, it has influence of ideology, influence of church, for example, as we have in Poland, in Lithuania. Additional problem is the understanding of obligatory character of international treaties, and again, control mechanism, how we can guarantee effective fight against gaps when we do not have possibility to influence on the state. So here you see that we have gaps, and we do not have effective legal tools to work with these gaps. And even this organization, which like intended to work with them, for example, trade union, they do not work with these issues efficiently, because it's not like a first point for them. It is a problem really now.
Thank you so much. And now we have a small break till I just